Major victory in the Supreme Court. We have the Biden student loan scam that they were trying to squeeze through using some obscure COVID protocols, saying that the pandemic justified the executive branch of the government just unilaterally writing off, waving away with a wand, huge swaths of debt. Doesn't really work that way. Congress passes the laws and the executive branch executes them. And it seems like the Supreme Court agrees. This opinion came out in Biden versus Nebraska. It's a 6-3 opinion drafted by the Chief Justice, John Roberts. And as soon as this opinion dropped, we heard in a great unified voice, thousands of students scream in despair for having to pay their bills. Now, this is what the opinion sounds like. It came out from the October term out of the Supreme Court of the United States of America. We're going to go through the head note here that the Education Act of 1965 is the governing law. This is the rule. And anytime we go through legal analysis, we often will break legal analysis down into a framework called IRAC, I-R-A-C. And this is issue, rule, application, conclusion, or analysis and conclusion. And some law schools, they'll want you to shove a little bit of an E in there for an explanation of the rule. So IREAC, issue, rule, explanation, application, conclusion. So it's the parts that you need in order to come to a good legal analysis opinion. You got to have these different things. So they're telling us that the rule is right here. It's the Education Act, 1965. The act governs financial aid mechanisms, including student loans. Now, the Act authorizes the Secretary of Education to cancel or reduce loans in very certain limited circumstances. And this is what they said, oh, COVID gave us this excuse to just do whatever we want. The law says the Secretary may cancel a set amount of loans held by some public servants. Look at the law. He may also forgive the loans of borrowers who have died or become permanently disabled, those borrowers who are bankrupt, another provision of the law, and borrowers whose schools falsely certify them, close down, or fail to pay lenders. All right, so the law, they're saying specifically, gives the Secretary of Education rules that they have to follow, and the rules say that this can only be applied in certain circumstances. So the issue here that's been presented is about the authority under the law, under the act called the HEROES Act. And can the Department of Education deviate and depart from existing provisions of the Education Act and then suddenly establish a student loan forgiveness program under this new act that will cancel about $430 billion in debt, just like that? Boom. And affect nearly all borrowers. Under the HEROES Act, the Secretary may waive or modify any statutory or regulatory provision for financial assistance as the Secretary deems necessary, here it is, in connection with a war, military operation, or national emergency. Did we just have one of those? Oh yeah, we did. Or at least they told us we did. As relevant here, the Secretary may issue such waivers or modifications as, quote, may be necessary to ensure that recipients of financial assistance are not placed in a worse position financially because of the national emergency. So the Biden administration, they just latched onto this provision and they said, perfect, COVID's been a national emergency. A lot of people are going to be in a worse position, really because they locked us all down and because they mismanaged the response in massive ineptitude fashion. So all of this is their justification. They say, well, I mean, we really want to buy these voters off, especially before the midterms. How can we possibly do this? I know what we'll do. We'll just tell them we're going to waive thousands of dollars from their bills. That's a good payoff. And they'll never know better. They'll vote for us, and then it'll get struck down by the court later. In 2022, as the COVID pandemic came to its end, says the Supreme Court, the Secretary of Education invoked the HEROES Act and then suddenly issued waivers and modifications, reducing or even eliminating the debt of most borrowers. Borrowers with eligible federal student loans who had an income under $125,000 in either 2020 or 2021 got eligible for a balanced discharge of up to 10 grand. Woo, nice. That's a nice little payoff for those voters. Those who previously received Pell Grants, a specific type of federal loan, qualified for up to $20,000. So what happened here? 6 states challenged the plan. They said, you don't have this authority to do this, Department of Education. Miguel Cardona. You can't just write off $400 billion of debt. The Eighth Circuit, when the states sued, issued a nationwide preliminary injunction, meaning the court said, yeah, you're right, they cannot just start writing all of this money off. And the court, when these lawsuits were going through, the government appealed, and now we're in the Supreme Court. Now, they give us a little bit of analysis here about standing. Missouri, at least, has standing. Why? Because they say they do, they spend money and so on. But the crux of the opinion tells us the HEROES Act allows the Secretary to waive or modify existing law, regulatory provisions that are applicable to financial assistance. Does have that power. But the HEROES Act does not allow the Secretary to rewrite the statute to the extent of canceling $430 billion of student loans. So what often happens is we have laws that get passed, and then we have regulations that come after the laws, and the regulations are how to apply the law, right? Congress is not that smart. So they write these laws saying, oh, this is the law, this is where the money goes, and so on. And then you'll have what's called the Code of Federal Regulations will often write regulations to interpret and apply the law. And so you'll have laws, and then you'll have regulations, and then you'll have other interpretations of the regulations, and it's a real complicated mess because that's our government. But here, this portion of this is only supposed to be interpreting the law, not supposed to be rewriting it. And what the HEROES Act has been doing, or what the Secretary of Education has been attempting to do under the HEROES Act, is to rewrite it, not just interpret it, and rewriting it to just cancel money. So the Supreme Court says, the text of the HEROES Act does not authorize this loan forgiveness program. The Secretary's power under the Act to modify does not permit them to permit basic and fundamental changes to the scheme. Instead, modification under the rules, it carries a connotation of increment or limitation, just slight adjustments at the margins. It must be read for moderate changes or minor changes. That's how the word is ordinarily used and defined, and a legal definition is no different. So the authority to modify statutes and regulations allows the Secretary to make modest adjustments in addition to existing provisions, but not to transform them. Judge Roberts continues. He says, prior to the COVID-19 pandemic, modifications issued under the Act were minor and had limited effect, but COVID changed everything. We know that now suddenly property rights don't matter because emergency. But the modifications challenged here create a novel and fundamentally different loan forgiveness program. They just created it out of thin air. While Congress specified in the Education Act a few narrowly delineated situations that could qualify a borrower for a loan discharge, and we covered those here. We saw those three delineated, that if you had any one of these provisions, if you were permanently and totally disabled, okay, discharge. The law says that's cool. You're bankrupt, okay, law says, all right, you've got nothing left, so you can maybe discharge some of those. And if you went to a school that is closed down and they failed to pay, well, then you can maybe get exempt. But otherwise, the law says it's pretty much clear. Now you have been adjusting it and extended this to discharge nearly every borrower in the country. Every borrower! It's highly unlikely that Congress authorized the sweeping loan cancellation program through the subtle device as permission to modify. But the government, the Secretary, and the Biden administration, they respond. They told the Supreme Court, they said, hey, sorry guys, this act does authorize us to waive legal provisions as well as modify them. So we're not even going to modify them, we're just going to waive them. And that this additional term grants even broader authority than the word modify. He says, well, we're not going to modify anything, we'll just waive it then. But the Secretary's invocation of the waiver power here does not remotely resemble how it has been used on other prior occasions, where it was simply used to nullify particular legal requirements. The Secretary, Miguel Cardona, next argues that the power to waive or modify is greater than the sum of its parts. Because the waiver allows the Secretary to eliminate legal obligations, the combination in the law, if you mash these two words together, called waive or modify, it's like 1 + 1 = 3. You get new powers. It must, just by logical extension, allow him to reduce them to any extent short of waiver, even if the power to modify ordinarily does not stretch that far. But the court says, the challenged loan forgiveness program here, it goes beyond even that. In essence, the Secretary has drafted a new section of the Education Act from scratch. Just wrote it by waiving provisions root and branch and then filling the empty spaces with radically new text. Because if Congress won't give them what they want, they just do it anyways. The secretary from the Biden administration also cites a procedural provision in the HEROES Act, directing the secretary to publish a notice in the Federal Register, including terms and conditions applied. Now, in the government's view, they say that language gives them permission to waive and put our own requirements into law. The court says no. But rather than implicitly granting the section and the secretary authority to draft these things, this part of the law simply imposes an obligation to report the waivers. You don't get to make new ones. You just got to report it. The secretary's ability to add new terms in lieu of the old is limited to his authority to modify. As with other modifications, you cannot distort the fundamental nature of the provision. So they say here, in sum, the Secretary's comprehensive debt cancellation plan is not a waiver because it augments and it expands previous provisions dramatically. It's not a modification because it constitutes effectively the introduction of a whole new regime. And it cannot be some weird Frankenstein combination of the two, because when the Secretary seeks to add to existing law, the fact that he has waived certain provisions does not give him a free pass to avoid other limits to modify. Quote, however broad the meaning of waive or modify that he wants to use, that language cannot authorize the kind of exhaustive rewriting that has taken place here. The Secretary responds, and this is John Roberts writing. He says the Secretary also appeals to congressional purpose, saying, you know, they passed this law and they wanted to grant substantial discretion to the Department of Education in the event of unforeseen emergencies. That's what Congress intended. The court says, okay, well, on this view, if we accepted that, the unprecedented nature of the Secretary's debt cancellation plan is justified by the unparalleled scope of the pandemic. But the question here is not whether something should be done. Who has the authority to do it? As in the court's recent decision in another case, given the history and the breadth of the authority asserted by the executive, the court has reason to hesitate before concluding that Congress meant to confer all of that authority. Remember, we have three branches of government, and for some reason, our Congress is so weak and pathetic that they often just delegate stuff over to the executive branch to do. And you'll find this in your local states as well. Your state legislatures will also say, oh, it's really complicated for us. I don't want to deal with it. Why don't we give this power over to the Secretary of State? And it happens all the time. And so now the court is saying, wait a minute. If Congress is going to give over to education the power to just nuke $500 billion in debt automatically, that's not going to be the standard procedure here. We are going to put some speed bumps in this and not just defer to Miguel Cardona's authority. This case implicates many of the same factors present in other cases where we had similar separation of powers concerns. The Secretary has never previously claimed powers of this magnitude under the HEROES Act. No regulation on this has even begun to approach the size or the scope of this program. The economic and political significance of this action is staggering, and the Secretary's assertion of his newfound administrative authority has conveniently enabled him to enact a whole new program that Congress has chosen not to do itself. That's why we have a Congress. The Secretary argues that the principles explained in the West Virginia case and its predecessors should not apply here. But major question cases have arisen from all corners of the administrative state, and this is not the first such case to arise in the context of government benefits. Roberts says, all this leads the court to conclude that the basic and consequential trade-offs inherent in a mass debt cancellation programs are ones that Congress would have intended for itself. And so in these circumstances, the court has required the Secretary to point to clear congressional authorization to justify the program. But the HEROES Act, as the government points to, doesn't provide that authorization. In fact, it provides no authorization for the Secretary's plan when examined using the ordinary tools of statutory interpretation, let alone asking for clear congressional authorization. So therefore, because the statute doesn't say you can do this, it says where you can waive and what you can waive in limited circumstances. This is not an appropriate executive action. It's in violation of the law, signed and delivered by Chief Justice John Roberts. This is a 6-3 opinion, split along party lines. We've got Thomas, Alito, Gorsuch, Kavanaugh, and Amy Coney Barrett joining the majority, and we've got Kagan, who wrote the dissent, with Sotomayor and Jackson joining in the dissent. So this is what the main opinion looks like, and this is the dissent. Judge Kagan dissenting, joined by Judge Sotomayor and Judge Jackson. They say, in every respect, the court today exceeds its proper limited role in our nation's governance. So they want themselves to have less power, I guess. Some 20 years ago, Congress enacted legislation called the HEROES Act. The Secretary's authority was bounded. He could do whatever was necessary to alleviate emergencies. But when COVID hit, two secretaries decided to use their authority, and they suspended loan repayments and gave them extensions. The second continued that policy and then decided to give $10,000. And so now the court is overreaching. They're really upset about standing, an injury. We do not allow that plaintiffs bring claims when they haven't been injured. So basically they're saying this case should have never been brought. For years, this court insists that we should keep policy decisions out of our judicial roles. And they say they're just disagreeing with the interpretation of the statute. They say the statute, the law, the one that we just read, says that it does give the secretary broad authority to give emergency relief to student loan borrowers, including, look, by altering usual rules. When the secretary did, fits within the delegation, but the court forbids him to proceed. So this is just generic statutory interpretation stuff, and the majority has the majority. The Republican conservatives have the majority in the votes. They're going to read rules strictly and try to interpret it literally on the basis of what the law says. The left, the liberals, oftentimes are looking at purpose and effect and outcome. What does the outcome lead to? And they want student loans to go away, essentially. I think they would like to just federalize student loans, quite frankly, and the education system. So this is impeding that effort, and it's also a hurt for their team, or the Biden administration. So it's not really much more complicated than that. The court today is now accepting a case without standing. In other words, they shouldn't have accepted this case, and therefore this violates the Constitution because we are hearing it. And so that is the opinion. You can see the rest of this. It's a 77-page opinion. The dissent finishes. So in a case, not a case, they say this is not even a case that should have ever been brought. The majority overrides the judgment of the legislative and executive branches, which I disagree with. I think they're overriding the judgment of the executive branch, not the legislative branch. And eliminating loan forgiveness. Look at this. 43 million Americans, the dissent says, are going to be implicated by this. 43 million Americans thought that they were going to be getting 10 to 20 grand off their loans because the Biden administration lied to them and tried to squeeze this one through. And it's completely unconstitutional. It's not even contemplated in the secretary's power. The majority gets it right. The dissent doesn't. The majority actually read the law and says, look, here are the provisions that the law allows. Right here, Section 1078-10, Section 1087A1, 1087B, 1087C. This is where you can discharge and waive loans. You can't do it for 43 million Americans because you want to win the midterms. And there will be more of this. You know, the law is what the law is, but the people who are in charge are still going to be the people who are in charge. And so whether the court comes out with an opinion one way or the other, they're not going to stop. They're going to continue to try to find other ways and other mechanisms to waive the student loans, to federalize the education system, to make more of a communalism approach to everything that we do, where the government has more power, the citizenry doesn't. The people who paid their student loans off, who worked their butts off and paid their bills down, don't get the same benefits that other people do. And the U.S. government doesn't follow the rules in order to get that done. They wanted to go through Congress, and Congress passed a bill that said, you know, we contemplated this as a society, and we all sat around and said, you know, do we want to spend $100 billion on American students and education, or do we want to spend $100 billion on some foreign war some other place? What do we want to do? And if Congress came out and said, you know, $100 billion for Americans rather than for defense contractors, and they came up with a plan and they waived student loans or whatever at that point, that would be a different conversation, because that would be more democratic, to use their words. It would be the correct process, and there would be a lot less to argue about. But this is not that at all. This is the Biden administration saying that we have authority to do whatever we want. And they're dishonest about this. They knew they didn't have this authority. Anybody who reads the statute knows that they didn't have this authority. They tried to write off $500 million with the stroke of a pen, and they're going to continue to do it. It's a slap in the face to their voters, to these 43 million people who were led into this narrative that this was all going to be possible, who may have been planning for it, all got rug pulled courtesy of the Biden administration. And it's going to continue to happen. This is is the failure of government. The government promises solutions that can never be delivered, and for some reason, people will still keep following the leader of the Democrats right off the cliff.